Good morning. Thursday District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, gum chewing, or reading any materials. Thank you.
All right, this is case number 24-166139. This is JP Morgan Chase versus Allison Hendricks. The matters before the court. I set it on for review on today's date. Your appearance for JP Morgan Chase, please. For JP Morgan Chase, do I have Allison Hendricks?
Oh, yes, Your Honor. Christopher Royce, P49102, on behalf of the plaintiff.
All right, thank you, counsel. Good morning to you. I have Allison Hendricks on this matter. Please say something.
Allison Hendrickson. Yes, I'm here. Thanks.
All right, thank you. Good morning to you as well. Counsel, looks like I have a note on here regarding a dismissal and error. Can you update me as to where things are as an officer of this court?
Yes, Your Honor. There was, I think that at one hearing, I was in a breakout room and the court called the case, was errantly dismissed. You reinstated it, I think, probably at the same hearing when I came out of the breakout room. We have been in contact. Ms. Hendrickson is using a debt settlement company, and we're in contact with that debt settlement company, but they indicated they don't have the funds to make an offer at this time. And I know this has been sitting a while. I know the court wants to move it off its docket. I would just request that we get a motion for summary judgment date, and hopefully that'll spur the parties to settle the case.
All right, and this Allison Hendrickson, anything you wanted to add at this time?
I think I'd like to add that through the program, I've already settled 2 accounts. One is one payment from being paid off. The other is about over halfway there. The Chase account's the last one. I've never missed a payment, and I'm just gathering extra funds as well to address the Chase debt. So everything's on track, and I've never missed a payment. It's just that I just needed a little more time to gather more funds.
All right, and that makes sense. I'm going to go ahead and keep the case moving forward as I'm required to do. And my hope, of course, is that in the interim, the loop can be closed on this, maybe the parties find a way forward. So I'm going to set it up for a motion hearing date. In fact, I'm going to allow for a discovery and set a date for a pretrial conference. That pretrial conference date is also a motion hearing date. It's going to be like 60 days from now. So I'm looking at the 19th of May. That's the next time that you'll come to court, May 19th at 9:30. I will send you a scheduling order out in the mail today. You'll receive that in writing. It will have discovery is open through the 19th. We'll also have that 19th date as a motion hearing date, so long as motion is filed timely. The court will hear it on that same day. And hopefully in that 60-day or so period, the parties might be able to find a way to a solution. If you do that, that works out fine. If not, then I'll hear the case based upon any motion that might be filed at that time. However, I do wish you well, and you receive that order from me in the mail in the next few days.
Great. Thank you, Your Honor.
Thank you.
Thank you. I'm calling case number 24-160681. This is Luminaire Electrical Corporation versus Christopher Jackson and Penelope Jackson. It is an hyphenated name. The matter is before the court in regard to a motion for summary disposition. The court is in receipt of the same and in response to the same. Your appearance for Luminaire, please.
May it please the court, Matthew Norris, P36806. Also present on the Zoom is Mr. Damian Jackson of Luminaire Electrical. No relation.
All right, thank you, Mr. Norris, and good morning to you, sir, and to your client. For Christopher Jackson And Ms. Jackson, your appearance at this time, please.
Good morning, Your Honor. Jacob Khan appearing on behalf of the Jacksons.
All right, thank you, Mr. Khan. Go ahead and put your P number on if you will, sir.
P81817.
All right, thank you. And again, good morning to you. I take it the parties have had an opportunity to talk about this. I do have a motion in front of me. Any updates at this time? Either one of you, if you wish to speak for the plaintiff, any updates at this time?
No, Your Honor.
All right, so you may proceed at this time regarding your motion in this matter, counsel.
All right. Today's the date and time for the defendant's motion for a partial summary disposition and seeking a dismissal of defendant Christopher Jackson. Mr. and Miss Jackson reside at 18065 Hamilton Road in Detroit. Miss Jackson had engaged the plaintiff Luminaire Electrical to perform electrical work at the property. All of Luminaire's estimates were addressed solely to Miss Jackson. Likewise, all the invoices were addressed solely to Miss Jackson. The complaint is pled as a breach of contract, it says, against the defendants. However, it is undisputed the estimates are being used as the contract in this matter, and all the invoices and estimates attached are solely addressed to Miss Jackson. As a matter of law, Mr. Jackson, who is not a party to the case, cannot be sued for a breach of contract. And since Luminaire has admitted a contract exists, there is not an unjust enrichment claim to be brought against him, because Michigan law is clear. When an express contract already addresses the subject matter, unjust enrichment would fail. We don't have to really get into the nitty grits of the case, but nothing that has been attached to the plaintiff's response overcomes these allegations. There's no affidavit attached to the response brief, and the exhibits that are attached all still identify only Miss Lucy Jackson, who would be the only proper party in this case. Miss Jackson disputes the debt that's owed. She had to hire a replacement contractor to correct and fix the work. The violation notice that was called in for the inspection by her replacement contractor is attached to the affidavit. The debt is very much disputed, but this should proceed to a trial between Luminaire Electrical Corporation and Miss Lucy Jackson only.
Thank you, counsel. That was the thing that struck me as I began to look at this, Mr. Norris, as to the question as to how Mr. Christopher Jackson is brought into this. You may proceed at this time.
Can I say one more thing, Your Honor?
Yes, sir, Mr. Khan, and then we'll come to you, Mr.
There was a partial payment, or what our client contends is the entire payment that would be due to Luminaire paid. Prior to that, it's my understanding, Mr. Norris had filed a lien foreclosure action in Wayne County. Under a lien foreclosure action, a claim is also being brought against the property. In that litigation, it wouldn't be disputed that both parties would be proper since they own the property together. That case was dismissed as for no action and no service. I believe this was just a carryover caption that left the husband on the caption, but now that it's a breach of contract in this 36th district court, that's why we contend it's improper, since the contract truly is between the wife and the electrical contractor.
Mr. Norris, certainly that last argument, if that's, you're talking about suing regarding liens on property.
Nope, not a carryover caption. Mr. and Mrs. Christopher and Penelope own the house jointly. They both live there. They're both responsible. Luminaire Electrical is the second of 3 electrical contractors doing substantial electrical contracting, repairs, and upgrading. And Mr. Christopher Jackson is liable just as much as his wife Penelope. She contracted for improvements to the house that they live in, and there's a presumption when a spouse contracts for work to their house that it's done with the approval of the other spouse who lives there. Now, as far as the lien case goes, the case started at $22,000, Your Honor, and after it started and part payment was made, it brought this debt down to $5,912, and discretion is the better part of valor. So I brought this case for breach of contract. did not want to keep a 5009-12 case pending before Judge Snow in Wayne County Circuit Court. Then lastly, we're asking for counter summary disposition under 2.116I2 and judgment in favor of Luminaire Electrical in the amount of $5,912.
I don't see where you filed a counter motion. You're making that orally, you're saying?
It's in my response brief.
But you didn't.
And my response.
Well, you did put it in your caption that was something that you were asking for. Your caption is your response to the motion for summary disposition. All right, I got you, Counsel. Thank you.
In my wherefore clause, thank you.
Yeah, it's in your prayer for relief. Certainly not in your caption, and it's certainly not something that is significant highlighted, nor is there. Are there any significant arguments attached to the same? That notwithstanding, let me hear from you, Mr. Khan, regarding this issue of the presumption of the spouse under a contractual obligation.
I think the answer to it is under a C-10 motion, there was an obligation to bring a counter affidavit if they were going to contend that there was some agency here or presumption that he was bound by that. They haven't. So we're dealing with unverified attorney argument that A, wasn't briefed in the motion or the response itself, but hasn't been put forth properly in an affidavit to overcome the C-10 motion that was put forth by the defendants. In this matter, the documentation only identifies Miss Familucci Jackson. We're not disputing that a contract exists between Miss Jackson and Luminaire. We're disputing that one exists between them and the husband. There was no involvement of the husband. There's no document showing that the husband was involved or engaged with Luminaire. The contract is between the wife and the electrical contractor. And regarding the request under 2116I2, there's a genuine dispute as to whether there's any money due based on the electrical violation that was noted from Streamline Electric, who called in an inspection before he touched the property. And the city of Detroit confirmed there was violations based on Luminaire's work, which is why the debt is disputed. So summary disposition should be partial. Summary disposition should be granted to dismiss Mr. Jackson from the case. And this matter should proceed to a hearing to determine whether any money is actually due to Luminaire, which is disputed by Miss Familucci Jackson.
All right, thank you. I've listened to the argument on the motion for summary disposition and on the counter motion. Obviously, as it relates to the counter motion, I don't think the arguments are well formulated before the court on that issue. I'm going to deny that motion. But certainly that denial is without prejudice. If that is, if those issues are brought before me properly, motion, I'll certainly take a look at it, hear the appropriate arguments on the same. I just don't think that is set before the court, and at least on facially it seems that the heart of this case is that there is a dispute regarding the issue of the indebtedness. So that issue remains an open issue, and I would not. I could not resolve that issue on the motion for summary disposition as set forth. In relationship to the motion for partial summary disposition in this matter, I've looked diligently for a nexus to bring Mr. Jackson into contractual obligation here, such that Luminaire could survive the CTN motion. I don't see such a nexus. For that reason, motion for summary disposition or partial summary disposition is granted, and that the result of that motion is that Mr. Jackson is dismissed. The court finding that there is no basis set forth in this record in this motion on this complaint that establishes him as a contractual obligee under this the agreement that is argued between the parties at this time. For that reason, the motion, for those reasons, the motion is given.
Thank you, Your Honor.
All right, I wish you well. Good day to you, gentlemen.
Well,
Thank you, Your Honor.
Your Honor, I think this was also set for a final pretrial today as well.
Thank you.
So I didn't know if we were going to discuss further dates and a possible trial date today.
that the next thing would be for me to set this up for trial. I don't see a jury demand, correct?
That is correct.
All right. So let's go ahead and get a trial date set in this matter. Have the parties thought about mediation or anything along those lines?
Always.
All right.
I think Ms. Jackson wants a day in court, and I'm not sure mediation will be a way to resolve it. So I would ask for just a trial date.
All right, very well. So let me just take a look at a couple of things. So it looks like this is a claim for $6,000, correct?
Correct.
All right, so I'll go ahead and set a trial date and have parties come in and in person regarding the trial date. It seems to me that with those kind of numbers involved, that this is probably something parties should be talking about. So we'll take some time to try to deal with that. Madam Clerk,
We'll try to.
can I do this? In April, stretching.
29th.
29. All right, I'm gonna stick you in for the 29th of April at 10:30. April 29th, 10:30. That's in person, please.
All right. Thank you, Your Honor.
And if either party had some other motion that you wanted to file, you can certainly do so. I'll hear it on the date of trial. Just make sure that you get the proper amount of notice and set it for hearing on the date of trial. So 4/29 at 10:30 a.m.
Thank you, Your Honor.
Thank you.
Good day, gentlemen.
Have a good day.
All right, this is case number 23-164672. This is ASP Care Plus Pharmacy versus Farm Bureau. The matter is before the court, set on for a pretrial conference date. Your appearance for the plaintiff in this matter, please.
Isabel Arable on behalf of plaintiff.
Mr. Khan. Ms. Arable, go ahead and put your P number on, ma'am.
Sorry, it's 86220.
All right, thank you, Ms. Arable. Good to see you this morning. For the defendant in this matter, Farm Bureau, your appearance, please.
Good morning, Your Honor. Andrew Kraszewski on behalf of Defendant Farm Bureau, P76771.
Thank you, Mr. Kraszewski, and good morning to you, sir. All right, so I've got it set for pre-trial. I see us. I think I already dealt with some motions in this matter. So, why don't you go ahead and update the Madam Counsel regarding this matter? I know there was a show cause regarding a witness you were trying to, the defendant was trying to bring in. There was a deposition that was pending. So better yet, I think defendant in this matter, counsel, if you will, update me on what things are.
I'm happy to, Your Honor. So thanks in part to the bench warrant that was previously issued for her arrest for her failure to appear. We did take Dawn Barnett's deposition on the 28th. That's the mother of the claimant. Based on her testimony, the upshot of her testimony is that she believed the car that her daughter, the claimant, was driving was insured with Allstate. However, she had sold the car and did not have access to any of those documents herself. Therefore, we have had to issue some subpoenas to both Allstate and to LA Insurance, which we believe was the agency that sold the policy. And there's also some testimony that has come out that the claimant's brother, Julian Barnett, lived in the same house and also owned the vehicle. We are now going to have to try to obtain his deposition as well. We do believe we know where he lives, so I don't think that should take as long. But as your honor is aware, we've had some difficulty getting witness cooperation in this matter. I know it is a little bit on the old side, but we would nonetheless ask for some more time to conduct discovery. And really not so much from the plaintiff in this case, but from other witnesses that we need to speak to verify eligibility.
Wait, I'm sorry. We weren't at that deposition for Dawn. We notified that it took place or that it was pending.
Okay.
Wait a minute, what? All right, Ms. Arable, it wasn't clear what you said. You said you were at that deposition or you were not?
No, we weren't even notified of that deposition. So I'd actually really like the transcript of that deposition. And I'm not sure why we weren't notified. And if the brother's deposition is going to take place, I'd like to be there.
Let me see if we've received the transcript yet. And I'm sorry, I'm not aware of who was. I think this probably would have been noticed through the claimant's case. So I apologize if that notice was not given. I don't see a copy of the transcript yet. This is 2 weeks ago. That's a little surprising, but I will certainly make a note to pass that along to you as soon as we get it. I don't think we have noticed Mr. Barnett's deposition yet, but likewise, when that occurs, I'll make sure that your office is copied on that.
Please, thank you.
All right, well, it seems that some progress is being made. This is a 2023 case. We're in 25. So it seems, counsel, that's counsel, that we still, there may be some issues out there as to whether or not the state farm should even be in, farm bureau should be in this, that kind of what the issue is here.
Yeah, so Farm Bureau is an assigned claims carrier. If there's any priority of insurer out there, they would then move it to higher priority for payment. So that's the primary issue. There are other substantive arguments, and there've been IMEs and things of that nature, but really the primary issue being investigated at this point is priority and eligibility for assigned claims coverage.
All right. So I will. I'll adjourn the pretrial in this matter and set a new date. I will order that any transcript generated regarding the Dawn Burnett deposition be forwarded to plaintiff's counsel, and that notice be given to her regarding the deposition that is anticipated regarding Mr. Burnett. So
Thank you.
let me bring this back some 45 days from now. Let's see where we are at that point. So I'm going to go ahead and set it over for.
And then I'm sorry, Your Honor.
Yeah, I'm sorry, I have my face covered. I'm looking at the calendar and talking at the same time.
Right.
The 30th of April? Yeah, the 30th of April at 9:30.
I'm sorry, what was that date again?
April 30th, 9:30 a.m.
Got it. Thank you.
All right, good day to both.
Thank you, Your Honor.
Yes, I appreciate that, Your Honor. Thank you. Have a good morning.
The court now calls case number 24152636. This is Rodnick Chiropractic versus Essentia Insurance Company. The matter is before the court on motion for relief from a previous order of court. Right, your appearance for Rodnick Chiropractic, please.
Your Honor, I don't believe Mr. Fortner has logged on just yet. He's still on another hearing in the civil court. He should be over here shortly. He's got a couple in front of you this morning.
Thank you. For Essentia, do I have counsel for Essentia present?
You do, Your Honor. Kevin Thomas on behalf of Essentia P77794.
All right, thank you, Mr. Thomas. I'm I'm gonna stand by a bit on this and I'll recall it shortly, see if we can get this report here. If not, I'll adjourn it over and we'll get it right back. I don't want to hold you too long. I know it's set for 10. So let's see.
Fair
if
enough.
Shortly.
Thank you, Your Honor.
I'm like, all right. I see it now. I've lost my form. I see another one.
Yes, yes, true, yeah. And his third one was dismissed.
Okay, so
You should only have just the body mechanics, which is the 635 and the 636. Those are your only two that's left. The laboratory, did you do 632 yet?
I'm getting ready to do that.
Yeah.
I thought two of the district ordinance were settled.
No, one.
One was,
Yes.
okay, that's fine, that's good.
Yeah.
Gotcha. Thank you. All right, this is case number 24158632. This is Michigan Pain Management versus Laboratory Specialists of Michigan and Smart. Your appearance at this time, please.
Good morning, Your Honor. Alicia Rubin appearing on behalf of plaintiffs, P78962.
Thank you, Ms. Rubin. Good morning to you for defendant or defendants. Your appearance, counsel.
Good morning, Your Honor, and may it please this most honorable court, Caitlin Crapo, P86272, just on behalf of SMART. Just for the record, I do believe it is Michigan Pain Management and Laboratory Specialist v. SMART. I believe there's two plaintiffs and one defendant. I might have it wrong, but that's.
Yeah, I see what you're saying now. Yeah, the case is styled as Michigan Pain Management and Laboratory Specialist of Michigan versus SMART.
Yeah.
All right. So I see that there is I have a motion filing on the 4th of March. And I don't think motion to compel responses to discovery. Like I said, there's a notice on that that tells me that it was filed report of the 4th. So go ahead and update me where things are at this point, given the defendant has filed this motion. Madam Counsel for defendant, give me an update as best as you.
Sorry, Your Honor, if the motion to compel the discovery responses, I provided those yesterday to counsel. So they should have them.
Your Honor, we are in receipt of them, but this was a motion to compel and a motion to adjourn due to the fact that we just received these yesterday and we have not been able to do any other discovery. I don't want to argue the motion today, but unless the court prefers that, but.
All right, so the main issue now is you are asking the court for an adjournment under all the circumstances.
Yes, Your Honor.
Ms. Rubin?
I'm not sure how much more discovery they need, but I'm fine with an adjournment. I sent a demand yesterday. This isn't a ton of money that's due, but I understand that if they need more discovery, then I'll defer to the court.
Thank you, counsel. So, so Ms. Greco, I reviewed this in 30 days. You think that's a meaningful period in this regard?
An additional 30 days, Your Honor? Is that what you're, I'm sorry.
I think to set it out 30 days from now and take another review at that point.
Yep, that would work, Your Honor.
All right, so let me go ahead and set it. Well, that's going to put us at the 28th of April because I'm away the week of the 21st. So April 28th at 9:30. April 28th at 9:30.
At 9:30? Okay.
Yes.
Your Honor, it's going to be a motion hearing or a pretrial? Apologies for interrupting.
It's a pretrial. Your motion is Your motion is yet pending. So technically speaking, if it needs to be argued at that time, I'll address it at that time. There was a suggestion that the discovery has already been turned over. But there are some remnants of that you wish to argue, that you take that up on the 28th. So everything is adjourned over to that.
Absolutely, Your Honor. We'd be willing to withdraw the motion if, we were given an adjournment for discovery, or if plaintiff's counsel would stipulate and we could submit something as well.
Well, I'll leave discovery open through the 28th.
Absolutely.
Okay.
I'll note that the motion is withdrawn under these circumstances, and then I'll review that on the 28th and see where we are at that time. I know it's not a lot of time, it's about 45 days. And let's see where things. All right. Good day to the children.
Thank you, Your Honor. We'll try to work this out too.
Thank you, Your Honor.
Thanks. Have a good day.
And 517. That I get 517 as the
No, the 19.
The 19th.
Yeah.
Okay, that's a Saturday. Mr. Thomas, I know that you are on the Rodnick matter. Are you on the body mechanic matter as well versus auto flow?
No, I am just on the Rodnick Ascension matter.
Thank you.
Your Honor, I apologize. Mr. Fortner is with Judge Sabri right now. He should be here just shortly. He's got two cases and he's currently on the record with her right now.
That's the update I was waiting for. Okay, thank you.
I had a question on something. Where about that woman who died in the van? The day phone. So legally, even though she had probably had sole custody, would both parents be responsible?
Yes, but their level of responsibility is potentially different depending on who was the primary caregiver. That's the issue.
Because the father had a house
Yeah.
and she asked him to get him, but he needed a good enough reason. But she didn't tell me why.
So yeah, they will look at all of those kind of things. If he knew the urgent nature of that situation, if he didn't have enough information urgent, it's just
But
what a terrible situation.
yeah, if you are an active father,
Yeah, that's
you know that your children don't have a place to live.
well, the part
If you in their life.
well, the part that you're doing, the part that you're addressing is what affirmative duty do you have as a parent? And yeah, that raises issues. But how it relates to the legal implications of being involved in their untimely death, that gets to be a little bit more challenging. A reasonable father, a reasonable parent is going to know the welfare of the children as they should. And can things happen where reasonable parents, reasonable parent, something happens that person could not have reasonably anticipated? Sure. And you know, you take a situation with one parent is bitter towards the other person. They shut down information and you just don't know what reasonable is finding out that could happen.
But her calling him,
yeah,
let me know
that's
that wasn't
that's the
to
issue
me.
of the circumstance.
Yeah.
That's what the challenge is going to be as they look at that is what were circumstances. Circumstances going to him neglecting the children. The circumstances point to that. So they have enough information. You know, and it'll come out.
Yeah.
All right, we're on the record regarding case number 24152-636. This is Rodnick Chiropractic versus Essentia Insurance Company. The matter is before the court on a motion for relief from the previous order of this court. Your appearance for Rodnick Chiropractic, please.
Your Honor, Michael Ford is here on behalf of plaintiff.
All right, thank you, Mr. Ford. Mr. Thomas has previously entered his appearance regarding Essentia Insurance Company. Welcome back, Mr. Thomas, and thank you for your patience regarding this matter. All right, Mr. Fortner, you may proceed regarding your motion in this matter, sir.
Your Honor, before we get started, is it possible that counsel and I can go into a breakout room?
Sure. Let me
discuss it.
Yeah, let me do that. Thank you. That should be easy enough. Let me sound like that.
Okay, Your Honor, we're back.
All right, welcome back, gentlemen. And, where are we? Anybody want to update me this time?
Kevin, you want to? Would you like me to?
Yeah, sure. So I was talking with Mr. Fortner. He's going to go to his client and get us a settlement demand, hopefully within the next week or so. And so if the court would be amenable to just moving this down the road a couple weeks, hopefully we'll just be out of your hair completely by then.
I agree, Your Honor.
All right, so let me go ahead and I'll just leave everything in place and set it over for the 27th. And that's just a control date. Obviously, if you get everything worked out, I'll get you appropriate paperwork. 4/27 at 9:30. 3/27, sorry.
3/27. All right, Your Honor, that'd be our pleasure. And,
Thank you, Your Honor.
Thank you, Mr. Thomas. Mr. Portman, you have another matter, which I think is resolved, but I don't see the other side. Let me go on the record with that. That's 24-158-635. That's Body Mechanic Physical Therapy PC versus Auto Club Insurance Company. It's I have it set for a pre-trial hearing. I know that there were offers of judgments or something that were exchanged in that matter. Any information?
We may have settled this one, Your Honor, but I can't recall off the top of my head. If you give me the same return date, I'll follow up with this one as soon as we get off and get an answer or have an answer for the court and on or before the 27th.
All right, sounds good. Sounds good, Mr. Ford. I'm gonna go ahead and set it over for the 27th at 9:30, and we'll review it at that time.
I'm looking forward to it, Your Honor.
All right, thank you, sir.
No, thank you very much, always. Talk to you soon, Your Honor.
All right, talk to you soon, sir. I know this there was some information in this file. So I just pulled out this stuff.
All right.
That file.
Oh, that's another.
Yeah.
That was the last one, Judge?
Yes.